Master. I'm an attorney at Jackson Lewis, and here today with my colleagues, Stephanie Keurig and Soline Malahaji. We're excited to be with you guys today, and we hope that this is a informative hour discussion on the 2021 employment law updates. Just at the outset, if you have any questions, please feel free to email us. All our emails are right there, and I think they're on our website too, so we're happy to follow up with you guys after. I'm going to begin, and I'm going to talk about the California Family Rights Act. As we all know, it is not new, but last year the act expanded to cover employers with 5 or more employees. While this expansion has been in place almost a year, we thought a quick primer on the California Family Rights Act may be useful. For those navigating it in conjunction with FMLA and those new to the compliance, the California Family Rights Act allows eligible employees to take up to 12 work weeks of job protected leave. It expressly prohibits an employer from refusing to hire, discharge, suspend, or discriminate against an employee in any manner for requesting the leave. It's like FMLA, but it is more expansive, especially with the coverage of 5 or more employees. As we said, it was expanded from applying to employers with 50 or more employees to 5 or more. Last year's amendment also eliminated the requirement that the employees had to work at the same site or within 75 miles of the same work site. Much like FMLA, employees must meet certain eligibility requirements in order to take CFRA leave. They must have been employed for at least 12 months and worked 1,250 hours of service within the last 12 months. Under CFRA, an employee can take leave for the following reasons: up to 12 weeks of unpaid job protected leave to bond with a newborn child or placement of child in employee's home for foster care or adoption, to care for a seriously ill family member, to recover from a worker's own serious illness, or to address qualifying exigencies arising out of a family member's deployment. And they could take leave up to 26 weeks to care for an injured service member. This year, compared to last, a minor change was added to the CFRA, which was to add parent-in-laws as covered under parents. While parent-in-law was a defined term in last year's amendment, they somehow got left out of the actual coverage. In this year, parent-in-laws got added for actual coverage, but both for care of a family member, but also for a qualifying exigency. Effective as of January 1, 2022, the Assembly bill provides that employers must grant eligible employees up to 12 weeks of job protected time off from work annually to provide for a parent-in-law with a serious medical condition. As we just stated, this bill modifies procedural aspects of the Department of Fair Employment and Housing's pilot program for mediating family leave disputes between small businesses and their employees. So with this year's amendment, family members under the California Family Rights Act includes all of the following: child, including adult children, a parent-in-law, as we just discussed, a sibling, a spouse or registered domestic partner, grandparents, and grandchildren. Now we're going to talk about the notices and forms that apply that an employer should be aware of. Within 5 business days after the employee requests or the employer learns of a need for leave, the employer must send a notice of eligibility and rights and responsibilities. If the employee is not eligible for leave, then the employer must send a designation form denying leave because the employee is not eligible with reasons. And if they are eligible, you're supposed to include a certification form, and the employee has 15 days to return the completed certification. Of course, we can't forget the California state brochures, which include the state disability insurance provisions, DE 2515, when the employees are injured or disabled, the paid family leave pamphlet, when an employee needs a time to care for a family member, and the DE 2320, which is the For Your Benefit, California's program for the unemployed, for any employee leave, whether for themselves or a family member. Of course, it is important that employers who need to comply with CFRA are aware that they need to use special forms, as you cannot ask for diagnosis or medical conditions. You cannot ask for anything beyond the regulations. And that includes medical information and medical history. The designation notice must be received within 5 business days after receiving certification or determining the employee's leave is disqualifying. You either send an approving leave or denying leave and explain why the leave is denied. And this is important as the recertification is different under CFRA, as periodic check-ins are not allowed. Only after expiration of time period originally estimated by the healthcare provider, and if additional leave is requested. And then upon receipt of recertification, the employer must issue a new designation notice. And for health benefits continuation, the employer must pay for the duration of the leave as if the employee was still an active employee. That said, if an employee has a monthly premium, the employee must still pay it unless the employer policy provides otherwise. I'm going to now pass the mic over to my colleague Stephanie to discuss with you updates in wage and hour.
I'm actually handling this section.
Oh, sorry, Solene.
That's okay. No problem. Hi, everyone. I'm Solene Melahaji, and we're going to get into the exciting world of wage and hour law. Here, we're going to go through a couple of case law updates. All right. First things first, meal period rounding. So rounding time punches has been a common timekeeping practice, especially at the start and end of shifts. And the California courts have upheld rounding as acceptable. However, in a case opinion this year by the California Supreme Court, they held that rounding may not be applied when employees are clocking in and out for meal periods. In the decision, the court gave an example of how rounding negatively affects employees because a meal period, for example, they used that was 21 minutes from 12:04 p.m. to 12:25 p.m. would have been rounded up to a 30-minute lunch break. And then the meal break would have been deemed compliant and no premium would have been paid. Rounding on meal periods may also mean a meal period taken after the 5th hour, which would normally be deemed non-compliant, would potentially be deemed compliant and no premium pay would have been provided. So California Supreme Court ruled that meal period provisions, they're pretty much designed to prevent even the minor infringement on meal period requirements. The kind of takeaway for employers is that you might want to refrain from rounding meal break time punches and instead require exact time for meal period timekeeping. Employers should also consider timekeeping systems that can flag missed, short, or late breaks. All right, meal and rest period premiums. So Farah versus Lewis pairs with a prior case as it goes to how much an employee is to be paid for premium pay for meal and rest period violations. As we just discussed with a prior case, when a meal period or rest period is not compliant or is missed, an employee is owed premium pay for missing the meal or rest period or having a non-compliant period. The language of the statute requiring premium pay stated an employee was to be paid their, and I quote, regular rate of compensation. However, there was no definition of what that meant. And it's been a long debate about whether that meant an employee's hourly or standard rate, or if it was intended to mean regular rate of pay. A term of art which is used when discussing how much overtime and double premium pay an employee is paid. While regular rate includes all non-discretionary payments made to the employee during a pay period. The California Supreme Court in this case ruled definitively that the regular rate of compensation means the regular rate of pay. What this means for employees is they need to review their premium pay policies and procedures to ensure that the payments are being paid at an employee's regular rate of pay versus their hourly or standard rate of pay. Now, at this point, we're still waiting a decision on another California Supreme Court case by the name of Naranjo versus Spectrum Security, which asks whether meal and rest period premium payments that are not paid or are potentially underpaid could trigger a waiting time penalty. And we expect to get a decision in that matter sometime next year. All right, so a little refresher on the regular rate of pay. As you'll see on the screen, it includes all I always have trouble with this word. Yeah, let's pretend like I didn't say it. For employment payment to or on behalf of non-exempt employees. It includes, but is not limited to, shift premiums and piece rate, non-discretionary bonuses, including production bonuses, commissions, incentives, housing benefits, meals, payment for performing a duty. There's also certain specific calculations required for calculating a regular rate when employees earn multiple rates of pay in the same period or for flat sum bonuses. All right, Dynamex. So if you're not familiar with Dynamex Operations West versus Superior Court, you've likely missed a lot of California updates over the past couple of years. Dynamex was the case that changed the test of whether a worker can be classified as an independent contractor. And this was codified by the infamously known AB5. While AB5 states specifically that it applies retroactively, there was a question for those cases pending prior to the Dynamex decision, and if the new test for the independent contractor classification applied, or if the previously used multi-factor test known as Barillo applied. The California Supreme Court in Vasquez versus Jan Pro Franchising, which was a case pending before Dynamex, ruled that Dynamex does apply retroactively. So the ABC test, why did things change so swiftly? Because this is the test that employer had to meet in order to classify as an independent contractor. The hiring entity has the burden of proving all three of the following elements. First, the worker must be free from the control and direction of the company in connection with the performance of the work, both under the contract for performance of the work and in fact. Also, the worker performs work that is outside the usual course of business of the company. This has made the independent contractor classification a lot more difficult but it was put in place to prevent a classification of a worker as an independent contractor when someone else in the company is doing the same work and is deemed an employee. And lastly, the employer has to show that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as that's involved in the work performed. And in September of this year, the governor passed AB 2257, which amended AB5. All right. So this case involves AB5, which, as I mentioned, was codified, which codified the decision in Dynamex. At the start of 2020, the California Trucking Association sought to enjoin enforcement of AB5 against motor carriers under the premise that AB5 was preempted by the Federal Aviation Administration Authorization Act, also known as FAAAA. The FAAAA expressly preempts state law related to the price, route, however you pronounce it, or service of any motor carrier with respect to transportation of property. And the argument was that California, having different requirements for who could be deemed an independent contractor, that affected state law as related to the price, route, and service. So the district court granted preliminary injunction and the state appealed. The Ninth Circuit reversed, finding that AB5 was not related to the price, route, or service, and therefore dissolving the injunction against the enforcement of AB5. The California Trucking Association has filed a petition for writ of certiorari before the U.S. Supreme Court, and that's currently pending. Federal preemption. So in juxtaposition with the California Trucking Association case is the International Brotherhood of Teamsters versus Federal Motor Carrier Safety Administration. In this case, the Ninth Circuit ruled in favor of federal preemption. The Federal Motor Carrier Safety Administration, FMCSA, within the Federal Department of Transportation, is responsible for regulating commercial motor carrier safety. In 2018, the FMCSA determined that federal law preempts California meal and rest break rules for interstate motor carrier drivers who are subject to the FMCSA's rest break regulations. I think someone might be unmuted and the noise is coming through, just an FYI. So the FMCSA's regulation applies to commercial motor carrier drivers who operate interstate and meet other specified criteria. California's meal and rest breaks laws generally require commercial truck drivers to take more rest breaks at a greater frequency and with less flexibility than the federal regulations. California's labor commissioner, charged with the enforcement of California's meal and rest break laws, along with other pro-labor organizations, petitioned the Ninth Circuit Court of Appeal for review of FMCSA's preemption determination. On January 15th, 2021, the Ninth Circuit panel in the consolidated case of International Brotherhood of Teamsters versus Federal Motor Carrier Administrator held that the FMCSA's determination reflected a permissible interpretation of the Motor Carrier Safety Act of 1984 and denied the petitions for review. The Ninth Circuit's decision means that for now, interstate motor carriers need not comply with California's meal and rest break laws, but must comply with the FMCSA's rest break requirements. Interstate motor carriers are now permitted to implement uniform rules for drivers, regardless of whether the drivers operate within California. The Ninth Circuit decision may not mean interstate motor carriers are forever exempted from California's meal and rest break regulations. Before 2018, the FMCSAs held that the preemptions did not apply, and the new administration could reverse the FMCA's 2018 determination. All right, now we're going to jump to new legislation. Stephanie, please take it over.
Hi, everyone. I'm Stephanie Keurig. I'm also an associate with Jackson Lewis, and I'm going to be walking through a few pieces of new legislation this year that affect employment law in California. So first we have Assembly Bill 286, which goes into effect January 1st of 2022. There are three main aspects of this bill. Firstly, it prohibits third-party platforms from charging more than the price set by the food facility. So, we're talking about these Grubhub, Uber Eats kind of platforms. The second major part of the bill is it makes it unlawful for the food delivery platform to retain any portion of tips, whether those tips are for the delivery driver or for the food facility. And thirdly, Assembly Bill 286 requires that food delivery platforms provide a cost breakdown of each transaction to both customers and restaurants. So this would include the cost of the food, any service charges, tax, or any other fees. Next is Assembly Bill 701, also going into effect January 1st, 2022. This bill targets warehouse distribution centers, and the main focus of the bill is requiring covered employers to provide detailed notice about quotas that apply at the time of hiring new employees. The bill expressly prohibits any quota that prevents an employee from meal or rest break compliance, using bathroom facilities, or traveling to and from the bathroom, or complying with California's occupational health and safety laws. Also going into effect January 1st is Assembly Bill 1003, which creates a new type of grand theft for an employer's intentional theft of wages or gratuities in an amount greater than $950 from any one employee, or over $2,350 in the aggregate from two or more employees. And that theft would have had to occur within a consecutive 12-month period. The new legislation also allows wages, tips, or other compensation that are the subject of a prosecution to be recovered as restitution in that action. Right now, we don't have any clear guidance on what the intentional verbiage in Assembly Bill 1003 means, but we believe that it suggests that it would have to be more than a mistake or inadvertence. And as Celine had briefly mentioned in her presentation, we now have Assembly Bill 2257, which the governor passed this most recent September and amends AB5. AB 2257 still maintains the essential framework of AB5, and the ABC test remains the default standard for independent contractor misclassification. However, AB 2257 exempts more California workers from the ABC test, and these expanded exemptions include still photographers, photojournalists, freelance writers, editors, and newspaper cartoonists who work under a written contract. The exemptions also apply to occupations involving sound recordings or musical compositions, musical groups for single engagement performances, think, a string quartet at a wedding, or individual performance artists. And the exemptions also apply to underwriting inspections and related services for the insurance industry, landscape architects who are licensed, and real estate appraisers and home inspectors. This year, we also saw Assembly Bill 1561 come into play. This just extends the sunset dates on exemptions that were granted to licensed manicurists and construction, trucking subcontractors from the provisions of AB5. AB5 still sets forth the test for whether a worker is an independent contractor or employee. We also saw the introduction of Senate Bill 646. This bill limits janitorial employees who are unionized and covered by a collective bargaining agreement that's in effect before July 1st, 2028, from filing a suit under the Private Attorneys General Act of 2004. Us wage and hour practitioners know that as PAGA. I'm sure it's an old friend to many of you. So under Senate Bill 646, these janitorial employees are no longer authorized to bring a civil action under PAGA if their applicable collective bargaining agreement provides for wages, hours worked, including overtime, and working conditions, and fulfills other specified criteria. Under this bill, janitorial employees include those employees whose primary duties are to clean and keep in an orderly condition commercial working areas and washrooms, or the premises of an office, multi-unit residential facility, industrial facility, healthcare facility, amusement park, convention center, stadium, racetrack, arena, or retail establishment. This exemption does not cover certain employees, which would include workers who specialize in window washing, housekeeping staff who make beds and change linens as a primary job responsibility, workers who work at airport facilities or cabin cleaning, employees at hotels, card clubs, restaurants, or other food service operations, and grocery store employees and drug retail employees. We also have Senate Bill 639. This is a big win for advocates of people with disabilities because this bill phases out the sub-minimum wage certificate program. So that program allowed for the payment of less than minimum wage for employees who have physical or mental disabilities. Under Senate Bill 639, that program is going to be phased out by January 2025, so that even employees who suffer from physical or mental disabilities will be making at least the minimum wage. And there will not be any new special licenses issued for the program after January 1st, 2022. As one final reminder, California continues its climb to the $15 minimum wage. There are also many local cities throughout the state who have implemented their own minimum wage ordinances that will also go up in January. And many employees in these cities who have enacted such ordinances are already higher than the $15 state minimum wage. And with the California state minimum wage going up, there's also an increase in the thresholds for California white-collar employees, including executive, administrative, and professional industries. So this table lays out the new minimum salary requirements for an employee to be exempt from wage and hour laws under the white-collar exemption. As noted there, certain wage and hour requirements and sick leave have a collective bargaining exemption, which requires union employees to make 30% above the state minimum wage, which means the minimum wage rate must be $19.50 in 2022 if the employer is relying on a CBA exemption to this requirement and other wage and hour laws. So that concludes our program, what we have prepared. I know we've finished this a lot sooner than expected, but we're happy to check the chat box or answer any questions that anybody might have on these topics. Okay, doesn't seem that we have any questions. So with that, like Lana had mentioned at the start of this presentation, all of our email addresses are on the first slide. They're also on our website, jacksonlewis.com. You can find us through the San Diego office page of the website. If you have any questions or want any further clarification, please feel free to reach out to any one of us.